So today I'm just going to take you through a couple of years of research answering 4 key questions. And the first is, why does medical debt matter? Why should you care about this? Why are you here today? Well, it makes it harder for Tennesseans to get ahead, to achieve good health and economic prosperity. Medical debt can crowd out spending on basic needs. It can feed cycles of debt associated with economic instability, like using credit cards or payday loans to pay off debts. Debt can make it harder to make the kinds of investments that help build long-term wealth, like setting aside savings for a down payment or retirement. And because medical debt can hurt your credit score, it can also affect access to the kinds of credit that are associated with building long-term wealth and economic mobility, like a mortgage. It can create barriers to employment and make things like housing and utilities more expensive. And it can also affect health. Debt-related stress can negatively influence health behaviors like smoking and poor nutrition. And people with medical debt are also less likely to access the care that they need. So what makes medical debt unique from other types of consumer debt? It can often result from circumstances that can be tough or to predict or control, even for people with health insurance, like an unexpected medical need, out-of-pocket health insurance costs like copays and deductibles, coverage disputes, and billing errors. So while providers and insurance companies may have to work out disputes between themselves about coverage or errors in the billing process, the patient is on the hook for paying the bill. And finally, unexpected out-of-network charges or surprise bills. And that happens when you might go to an in-network hospital, but unknowingly receive treatment from an out-of-network provider. Okay, so who has medical debt in Tennessee? These are just a few recent headlines about medical debt in Tennessee, but how common is it really? What do the data say? At the end of 2020, about 1 in 5 Tennesseans with a credit report, or 20%, had medical debt on their credit history. And that was the 7th highest rate of medical debt in the country. So we've been following this data for a couple of years now. And while the rate of medical debt has gone down, our ranking, unfortunately, has gone up. So I think when we first presented this data a couple of years ago, we were the 10th highest in the country, and now we're the 7th highest. Here's how that varies across the state by county, from a low of 8% of folks in Williamson and Pickett counties to a high of 35% in Cott County. To put that in context, this little green sliver is the US medical debt rate in December of 2020, 18%. Now here's all 95 counties in Tennessee from lowest to highest, and only 6 counties' rates were lower than the national rate. 1 county was the same, and 88 counties were worse. We also found that medical debt was common across most demographic and socioeconomic groups, but it is more common among some folks, including individuals who are uninsured, those with lower levels of income and lower levels of education, and people of color in Tennessee. So what can we do about it? To identify a comprehensive set of policy levers, we looked at the continuum from clinic to collections. Now I think we're saying from clinic to collections to courtroom, because we've learned so much about how medical debt shows up in the courtroom. So it begins with that visit to the doctor that triggers the medical expense, to the unpaid medical bill, and to all of those downstream impacts on credit history and economic stability that we talked about just a minute ago. So out of this review, we came up with a dozen potential policy levers. And those levers fit into 3 buckets. So first, prevent. So helping individuals prevent medical bills that they don't expect or can't afford. Manage, helping Tennesseans to better manage medical bills. And then mitigate, which is mitigating the negative effects of medical debt. So in the prevent bucket, we have things like addressing surprise billing, increasing enrollment in health insurance coverage, and finding ways to reduce out-of-pocket healthcare costs. In the manage bucket, we have healthcare provider billing and collection practices, ways to incentivize personal rainy day savings, expanding access to affordable small dollar loans, and supporting financial capability services like financial counseling. Finally, we have the mitigate bucket. So we look at ways that policymakers could rein in problematic debt collection practices and lawsuits, greater oversight of debt collection or credit repair services, limiting how a person's credit history can be used, and even directly paying off individuals' debts. So I'm just going to focus on very high level overview of some things that are relevant for today's discussion. So there are a growing number of reports, both nationally and in Tennessee, about hospital systems taking patients to court over unpaid bills. Court data that we looked at in Shelby County and some other news reports suggest that hospital lawsuits are frequent in at least some parts of Tennessee. But policymakers may want to dig deeper to better understand how common the practice is, what steps hospitals are taking with their patients before they resort to lawsuits. For example, do they offer payment plans? Do they screen for coverage options or financial aid eligibility? And then to what extent do these lawsuits even help hospitals financially? So related to that, debt lawsuits in general are very common. So for example, a hospital or provider can sell their bad debt to a third-party debt collector or buyer. And in fact, the debt can be bought and sold many times this way. And any entity that holds the debt has the right to sue as a tool for collecting it. There's a growing body of evidence that these suits may come with some issues. So one of them is notification. Individuals report never receiving clear or proper notification that they've even had a lawsuit filed against them. Inaccuracies. Some studies have reported that suits are brought based on inaccurate or incomplete information about debt. Unchallenged lawsuits. Most debt lawsuits go unchallenged, perhaps because the person never received notification, or they felt it was based on incorrect, misleading, or confusing information, or perhaps because they don't have access to legal representation. In fact, many people who do challenge lawsuits are unrepresented. This can give debt collectors an advantage. And then finally, added costs. So on top of the original debt and any fees and interest, court settlements often add attorney's fees, court costs, and post-judgment interest. This can inflate an individual's debt and result in garnished wages and seized assets. So I'm going to leave it right there. I'm going to go right into our discussion with Judge McVeagh, since we'll be focusing on a lot of these issues. So I want to give him a proper introduction before we launch into questions with him. Managing all my screens here to get his bio pulled up. So Judge McVeagh is one of 5 General Sessions Court judges with both civil and criminal jurisdiction in Hamilton County, Tennessee. Governor Bill Haslam appointed him as judge in May 2017, at which time he was one of the youngest judges in Tennessee history, as well as one of the youngest judges presiding in the country. Before that, he worked as a litigator at Chambliss Law Firm in Chattanooga, served as head research analyst and law clerk for the Tennessee Senate Judiciary Committee, and as an analyst and legislative liaison for the Tennessee District Public Defenders Conference. Most recently, the American Bar Association honored Judge McVeagh as one of the nation's top 40 young lawyers on the rise for his leadership, vision, innovation, and service to the community. So we are very honored to have him here today.
Thank you, Mandy. I'm honored to be here. And I mentioned this earlier, but I have, for whatever reason, hopefully everybody can see my screen. And if you cannot, please let Mandy know. But I am unable to see my screen. So hopefully you are seeing my entire face. But it's an honor to be with you all today. I know I've enjoyed participating in some Sycamore Institute panels in the past, as well as some presentations, a presentation at Vanderbilt, along with Mandy on this topic and some others. I know there are a few different folks here locally in Chattanooga, but all over the state, it looks like. So again, I appreciate being invited to talk about this issue, which obviously I'm going to bring to the table my perspective here in Hamilton County, Chattanooga, but at the same time, my court and these issues are very similar across the state, as Mandy just mentioned. We do have a similar set of rules for all small claims courts in Tennessee. So I think I can speak with confidence about some of these issues that happen in Chattanooga and say with confidence that they're also happening in other parts of the state. These are certainly topics that we address amongst judges, across the state at our general sessions conferences, but it's also a problem across the country. I've had the pleasure to participate in an Aspen Institute workshop in DC about similar issues and some solutions, particularly online dispute resolution that we're going to talk about today. So again, this is not this is not unique to Chattanooga, not unique to Tennessee, and it's an issue that we have all over the country. So pleasure to be here today, and I look forward to answering some questions and engaging in some dialogue with everyone.
Thank you. Why don't you just start off by telling us a little bit about what you see in your courtroom when it comes to medical debt lawsuits?
Certainly. Well, first, I know, and again, I'm looking at the list of folks, so I don't want to bore you with, courtroom procedures that some of you may already be aware of. So, but I do think it's worth mentioning kind of how a bill becomes a law, how a debt becomes a lawsuit and a judgment. And this goes for all courts across Tennessee and many across the country with respect to small claims court. Another unique perspective that I will touch on, because Mandy mentioned it at the very beginning of her presentation, is that in addition to civil jurisdiction, most judges, I know they're different in Memphis and I think some rural areas, but most small claims court judges in Tennessee also have criminal misdemeanor jurisdiction. So when we talk about issues such as fines and fees, pretrial detention, other issues, evictions, we are seeing the same folks on both sides of the courthouse, leaving the criminal side of the courthouse and appearing in the civil side of the courthouse in many of these same lawsuits, after they have concluded their criminal case. So again, I think these issues are all kind of interrelated. So I think it was important, the work that you guys are doing, particularly addressing a lot of these different issues. But in general, and to sort of simplify, when a provider, or let's just say any entity that believes they have a claim, that could be a claim for breach of contract, that could be a claim for a tort, somebody's been wronged or injured in some way. It could be a construction dispute, a car wreck, or in this case, breach of a provider agreement for medical services. If an entity or a plaintiff has a case, what they will typically do is either represent themselves or hire an attorney. Now, that attorney might be an outside lawyer at a law firm, or an individual lawyer, or an in-house attorney that works, for example, for a provider or for a large company. And that attorney will attempt to negotiate or attempt to demand a sum of money from an individual for a debt they believe they're owed or damages they are owed for some sort of tort. If that discussion that does not have any success, what will happen next is that attorney or that plaintiff will sue that individual, typically in small claims court. And in Tennessee, that court is called General Sessions Court. Uniquely, we have the largest small claims court jurisdiction in the country. So we're not talking about just small potatoes. And in some jurisdictions in the country, their small claims court only handles cases up to $1,000 or $5,000. Or commonly, I think in Georgia, it's $11,000. We handle cases here in Tennessee and have done so for quite some time for disputes that can total up to $25,000. So again, we're talking about certainly over the average hospital debt that I think Mandy's research has indicated close to $8,000 or so, but also from large construction disputes, large provider disputes, and again, these can be at times fairly large suits. In addition, plaintiffs can oftentimes, based on the language of their contracts with individuals, also seek attorney's fees. So again, those attorney's fees aren't always included in that jurisdictional limit. So again, we're looking at tens of thousands of dollars that can be collected in General Sessions Court. So after a plaintiff decides that he or she wants to sue an individual for damages, what they will do is file a case in General Sessions Court and then attempt to serve with process that individual. All right. After they have served that individual, and ideally that person then has notice of the case and are summoned to court on a particular date. Ideally that individual would show up to court, would have another opportunity to speak with that party and possibly the judge, possibly resolve that dispute in a way that benefits or both parties, or take it to trial. And again, may justice prevail, may the party with the claim that is meritorious actually prevail. Now that is an ideal world. What happens 9 times out of 10 is that excuse me, my screen is blank. That individual that was sued never shows up in court. All right. So as Mandy mentioned earlier, default judgments, winning by default, is what a vast majority of the justice that is done in General Sessions Court looks like. And so when just the hospital, or when just the credit card company, or when just the contractor is there in court that day, they win by default. There is very little that most courts and our laws require that provider prove to prevail on whatever suit they're suing for. So again, as Mandy mentioned, I mean, issues related to the accuracy of bills, issues related to the actual care that was provided, issues related to insurance that might have already covered certain procedures. Those are not brought to light because, again, that plaintiff gets to win by default. Oftentimes as well, when they are up before the judge, that plaintiff and the defendant is not there. Oftentimes they do not even have to bring their client before that judge. They can simply submit an affidavit from some custodian of records, from that company, from that provider, from that credit card company, from that manufacturer, that just states, this person, I was wronged, they owe me this much money. So that sworn affidavit is oftentimes the only proof that's presented to the judge, and is the only proof that makes up the ultimate judgment that goes down. After that default judgment goes down, in theory, the defendant has 10 days to appeal that judgment, and only 10 days. After 10 days, there is nothing anyone can do to set aside or appeal that default judgment. And there are some exceptions I'll talk about. But again, when we're speaking about small claims and medical debt lawsuits that are entered by default, and then all the downstream consequences that flow from those default judgments, it's very important that there's a 10-day window to undo any of the wrong that might have occurred by that default judgment. And so after 10 days, there are collection activities that the plaintiff can then take with a legal judgment, not just a debt that they've maybe written letters on, not just something they've reported to a credit agency, but a legal judgment that they can record at the courthouse. They can place liens upon property. They can garnish wages. They can levy someone's bank account. All collection tools that somebody now has by way of having a legal judgment, as opposed to just a claim. So that is how a medical debt becomes a legal judgment. Now, how do I see the majority of these cases in my courtroom? As we've already mentioned, I don't see them by way of an actual trial usually. Actually, and I'll mention this later, in the 4 years I've been on the bench, I have never presided over a medical bill dispute, a medical debt case. And I actually just as I was sitting here, realized that fact. I've actually never in 4 years presided over an actual trial. The thing that happens if the parties do show up is there's some resolution that occurs in the hallway, but ultimately, either by default judgment or by some sort of negotiated agreement between the parties out in the hallway, that is how that dispute is solved. It is never done by trial, which is interesting. Why do you think that? We'll touch on that in a little bit. But the ways in which I see these cases typically, since they're not resolved in front of me kind of pre-judgment, is I see an individual who comes to court when their light bills are due, their rent is due, and they go to pay those bills, and they realize that $800 has just been taken out of their paycheck. Those individuals oftentimes, panic, realize that it is some judgment creditor that has taken those funds, and they rush to court and they file a motion with me, help me, my wages have been garnished. I need to release this garnishment. I need my paycheck. What can I do? So at that time, that is when I see a vast majority of these judgment debtors, they come to me. Now, again, that 10-day period is very important, because if they come to me after those 10 days have already lapsed, there is very little that I can do. Oftentimes they try to tell me, I was never served. I never knew of the lawsuit. Yes, I owed this debt. Yes, I owed this credit card or medical debt, but it's not the right amount. It was only, a couple $100. Now they're trying to garnish tens of thousands of dollars from me. And all I can do at that time is try to help them with some sort of payment arrangement, some sort of payment plan on the back end. But my hands are tied as to what I can do. I don't have the legal jurisdiction to get into the nuts and bolts of the underlying case. I've lost that ability. So that is one way. That is the most common way I see these folks, is after the fact, rushing to me, trying to complain about that underlying debt that they might not have known anything about. Now, if they challenge that they were never properly served, I never knew about this debt, you might think that, well, okay, let's say, sometimes this does happen. Let's say sometimes someone with a common name, John Smith, is sued and a judgment is taken out against him, and they find out later by way of reviewing their credit report or having their wages garnished, oh no, like, what is this Tennessee John Smith? I mean, I never even lived in Tennessee. So they'll come to me. And if they're and that's, would seem to be somewhat of a more manageable way to prove, well, on such and such a date, I was not in Tennessee. I never lived here. But the problem comes that after those 10 days have lapsed, the burden of proving that you never got something is shifted from the plaintiff, who has to prove that they should win in a lawsuit. It shifts to that debtor, that defendant. And the example I gave is kind of an easy example. They might be able to prove on such and such a day I lived in Georgia. But for the majority of folks that are claiming they never received notice of this lawsuit, it is very hard to prove that you didn't get something. I mean, and especially when it's years and years later. And these judgments can be renewed every 10 years. So these judgments can be out there. I mean, somebody could be coming to court 20 years later trying to somehow prove to me that they did not receive service of process. So again, it's just a very, very high bar. It rarely ever happens. And so again, after those 10 days have lapsed, there's really nothing that I can do to remedy a situation. Another just kind of important note before I've rambled a little bit, but I just want to make sure everyone's aware. I, as a judge, have certainly an interest that justice is done. And that when we talk about access to justice, and it's important to me that the correct party wins. And I guess it's just I'm not really able. I cannot litigate on behalf of a defendant who is not there. Same way as I cannot litigate on behalf of a plaintiff that doesn't show up. If a plaintiff doesn't show up to sue and a defendant does, I must dismiss the case, even if I believe the plaintiff has a good claim by reading, the papers. But if he doesn't show up, if he's not there, my hands are tied. I must dismiss the case. If a defendant doesn't show up and it looks like they were properly summoned, then I must, rule for the plaintiff. So again, I just want everyone to be aware of what has happened the majority of time, what is happening in our general sessions courts. And then finally, I mentioned access to justice. I think it's really important because I see some folks on this call that have an interest in the criminal justice system. I think it's important that on the civil side of your respective courthouse, it's important to note that our Constitution, the state, our federal, does not provide any right to counsel for a civil litigant. All right. So whereas if somebody is being taken advantage of by the state, or if there is an incorrect charge or an incorrect citation that's issued on the criminal in criminal court, and if somebody is indigent and can't afford a lawyer, one is required to be appointed to them. On the civil side, that's not the case. We do have some very good civil legal aid organizations, but they have very strict guidelines on the persons that they are allowed to represent. You must meet certain poverty thresholds. And now again, so they might not be able to assist a litigant who, might not be poor enough, to qualify for their assistance, but still might not owe that debt. So as Mandy mentioned, a disparity in terms of the the representation and the ability to negotiate and the equities that might be involved for folks that are unrepresented on the civil side.
Thanks for that. You covered a lot of really interesting things. I even learned some new stuff every time I hear you speak, I think. So talk a little bit about this new project. So Hamilton County has launched an online dispute resolution pilot program for certain medical debt suits that would have otherwise gone through your courtroom. So talk a little bit about what exactly online dispute resolution is, why was that something that you pursued, and what problems, well, I guess you went through a lot of the problems. So talk about how it addresses some of those problems.
Yeah. So really, and Mandy, I will give the Sycamore Institute, a shout out here. This idea was kind of birthed with a group of individuals from Tennessee at an innovation conference involving courts from across the country in Louisville a few years ago. And it was at that time that we had representatives from the mediation world. I was there, representatives from legal aid and the Supreme Court were all there on behalf of Tennessee. And at that time, your organization had just, I guess, issued some of its first medical debt reports about the dire situation, relatively speaking, occurring in Tennessee with respect to medical debt. So when we were at this innovation conference, we were hearing about some of the ways technology was being used across the country, and particularly in some small claims court and traffic courts across the country. Again, to help the backlog of cases that some of these jurisdictions were seeing, to help hopefully facilitate justice in their particular area. But we sat and listened, and the state of Utah actually designed an online portal in-house for their state. I think their jurisdictional limit, though, is only about $5,000. There were a lot of private companies there talking about the work they were doing in traffic courts and some small claims courts. And so when we were thinking, that group of us there, we started thinking with, having the medical debt report from Sycamore recently issued, and, we were thinking, what could we do to try to address this situation, and what is a manageable, I guess, sample set to try to start a pilot. And so with with the medical debt information, we thought, well, this particular sort of debt might be a great place to start. And then who knows, maybe if this is a successful program and we're able to successfully use technology to resolve disputes, we might be able to scale it up, across the state and scale it up into other subject matter areas in addition to just medical debt. So we sat down and we met with some of the other folks from across the country. And I'm not sure who, I certainly won't take the credit for this, but somebody at that point said, well, all of these tools that we're learning about are being used after a lawsuit's filed. Now, another important point to note is that after a lawsuit's filed regarding any sort of debt, it oftentimes the provider contract or even a particular statute under Tennessee or Georgia law, oftentimes that statute allows for the plaintiff to, if they prevail, to receive attorney's fees. Oftentimes, attorney's fees, which are deemed reasonable in Tennessee, can be anywhere from, a flat fee to a percentage of what they are collecting. Very common, at least in our court, is for if a plaintiff prevails on a $10,000 debt, their attorney charges and receives a third of that. So they can then charge that, they can seek from the court, if they were to win, that $10,000 plus the $3.33 thousand dollars in addition. So again, bringing that judgment amount from $10,000 to over $13,000. The other thing that happens is after a party wins a lawsuit or wins by default, in addition to those attorney's fees that are added on top of that debt, there's also statutorily allowed and required post-judgment interest that goes on to a debt. So oftentimes, people might be familiar. Obviously, it goes without saying that if you're sued on a credit card debt and a judgment is taken, it wouldn't surprise anybody that your judgment would continue to accrue interest, typically at the rate of that credit card contract. But But most times a medical dispute or other issues do not contain interest. So a debt that wouldn't otherwise accrue interest is now accruing interest after that legal judgment is taken. So again, add on attorney's fees, add on that interest, and then all of a sudden, 10 years later, that judgment has grown exponentially. And then, as I mentioned before, a party might come to me to release the garnishment. I'll put them on a payment plan of $20 a month. Well, that $20 a month does nothing to that $13,000. It doesn't even, start to hit the interest, and that judgment continues to accrue over the years. So we thought, what if we use some of these tools to actually try to resolve this dispute before a lawsuit is filed? Which I've come to realize that this is one of the first pre-court online dispute resolution pilots that is out there in the nation. And again, it makes sense why I think a lot of jurisdictions haven't attempted to tackle this, because one, typically if somebody's not responding to a provider or a credit card company, if they're not trying to talk to them beforehand and resolve this, what makes you think they're going to do it before a lawsuit's filed? I mean, the weight of a lawsuit is what gets somebody ultimately to come to court or to dispute a debt. But we thought, but what if instead of any pre-court harassing phone calls, letters from a creditor, that a lot of folks, as you know, and Mandy's well aware, and the research shows, the whole, the head in the sand mentality. When folks get into cycles of debt, they often just don't even open their mail anymore. They just kind of hope to, pray it away and so, we thought, well, instead of a tool that someone might have a similar reaction to, what if we actually put the court's, I guess the respect of the court, or I'm trying to think of another word, but the legitimacy of the actual Supreme Court of Tennessee behind this program. So a debtor actually might have more confidence that, one, maybe they're not going to be taken advantage of. It's not going to be too overwhelming. The court's kind of looking over this. And then also, what if we threw in some free volunteer mediators to actually that are not affiliated with the hospital or with the debtor or legal aid, to actually try to help this conversation? So again, we thought that maybe if we threw in these tools beforehand, we could reach some resolution to some of these claims, and not have to go down the parade of horrors that you've mentioned, Mandy, about all the downstream consequences, and that I've talked about that occurs after that judgment. So that was the I guess the genesis of this pilot. Hamilton County was actually a great location, as your graphic showed earlier. It's one of the areas where quite a few provider lawsuits are actually filed. We are kind of a good cross section as far as urban and rural as to who is treated in our hospitals. I think we have the only trauma center in the area at our public-private hospital that brings in a lot of the rural folks. We also are a more urban area as well. We have a provider, HCA provider. We have Memorial Catholic Health provider. We have quite a few of the big four providers that are in our jurisdiction. So we thought Hamilton County would be a really really hopefully representative place to launch this pilot, and the Supreme Court of Tennessee is very interested in obviously seeing how it works here. So that was kind of the genesis of it all. We were able to partner with Erlanger Hospital, which is our kind of public-private provider here in Chattanooga. They're one of those providers that do file lawsuits if collection activities were unsuccessful, but at the same time, they were gung-ho to work with us, and I think for a variety of reasons. One, if you're a provider, why not reach some resolution on the front end rather than chasing someone down for years and years and years, or having to write off debt or sell it off? I mean, why not see if we can come up with some reasonable agreement about how to resolve this debt if you can? So obviously the provider has some incentive in this. There are also plenty of charity care discounts that a particular debtor could receive if they just talked to the hospital. I think that's an area. I mean, what I've learned in all this is that, hospitals aren't the bad guy in all of this. If anything, it's the cycles of debt, and it's the lack of communication that's the bad guy. And again, I'm not claiming that all those default judgments, that there weren't valid claims that a hospital had. But what I'm saying is, it's the lack of communication, and when two parties actually sit down, they can negotiate, and oftentimes they can resolve their dispute. So that is what we were trying to get at with this. The hospital was on board. Legal Aid of East Tennessee, representing the debtors' interests, were certainly on board, and our Supreme Court was on board to see if we could apply for some grant funding, which they were able to do, and to get this pilot kicked off. So we are in the beta phase, and I'm happy to kind of go into some of the early results, and also some of the other issues we've dealt with along the way.
Yeah, I'd like to hear a little bit about how it's going. I mean, I know I'll say from what we've learned about it in our conversations along the way is that your pilot was looking to accomplish some things a little bit differently than other online dispute resolution pilots had in the past, because in actually the events that I've been at with you or on the same panel, we've heard that other projects may be accomplished because you have three actors here. You have the court, you have the plaintiffs, and then you have the defendants. And a lot of the pilots in the past had maybe worked for two of those parties, but didn't work for a third one, or maybe was only looking out for, trying to reduce the dockets in the court. But you guys really have a three-pronged goal here, which is to make it work better for the court, make it work better for the hospital system, and make it work better for the folks that owe these bills, which I know we'll be really looking forward to seeing the results, and maybe even help figure out what those results are. Yeah.
And you said the folks that owe these bills, but it might also be the folks that don't owe these bills.
Yeah, that's right. That's right. Yeah.
And I will touch on that briefly. There, online or even any sort of mediation or arbitration, and certainly in the online arena, a lot of possibilities there. But oftentimes some of these ideas have failed in other parts of the country. I'm not sure if he's on this call right now. I don't see him, but I know we have had in the past some information about some of these pilots, and I know somebody, Larry Bridgesmith, who helped with some of these early discussions, helped in the New York space on an ODR pilot that kind of went awry, and in learning from some of these other individuals and what went wrong. I think one of the great lessons that we received is that it's vitally important to kind of take your time with this, and on any sort of project like this, to bring in all of the potential players that could be affected. So again, in addition to obviously the hospital and certain debtors, like i.e. represented by Legal Aid, representing their interests, it was also really important to bring in, some of those creditors' attorneys or some of the debt buyers, so that they would not have a huge backlash to this. Important as well to bring to the table, folks like the court clerks' offices. Many of our court clerks across the state are funded by filing fees. We are trying to implement a policy that is expressly, not filing lawsuits, and again, so it was really important, and the Supreme Court's Access to Justice Commission, as well as their Alternative Dispute Resolution Commission, really took on this project and agreed to be co-sponsors of the project, in addition to Hamilton County, and took the time to meet with folks representing bankruptcy interests. Again, oftentimes, coming up with some sort of settlement agreement might not be the best solution for a debtor. It might be bankruptcy, and so again, we're wanting everyone to, we wanted to bring everybody to the table when we were attempting to design this. We also want to make sure, again, that Legal Aid is involved throughout this whole process, as well as mediators, because again, this is not meant to just be another collection tool for a plaintiff or another a way to hassle somebody. This is not meant to be a court-blessed tool for a hospital. If anything, this is supposed to be a way in which, again, justice is done. Debts that have no basis can be resolved in the correct manner. And again, they're supposed to be there also to assist that debtor who might be rightfully or wrongly sued. So again, it was real important to spend a lot of time bringing together a lot of different people working through issues. Also important to note that this pilot has applicability pre-court, but also post-court. Similar to other jurisdictions, there is nothing that says when a lawsuit's filed and folks come to General Sessions Court. I know this happens in Nashville all the time. There are volunteer mediators, volunteer attorneys that are actually in the hallways in Nashville. And oftentimes what happens is that after cases are called on the docket, the judge tells them to go outside in the hallway and see if they can resolve this dispute with kind of an in-person pro bono mediator. That happens a lot in the Nashville Small Claims Court. So there's nothing to say that this technology could not also be used even after a lawsuit is filed. If it appears that there's some dispute, I think it would be reasonable for a judge to say, I want you to attempt to work this out before we schedule it for trial. This appears, the debtor saying that these bills are all wrong. The plaintiff saying that no, that insurance covered this when they really only covered this. I think it would be very reasonable for a judge to say, you guys take that outside, take that online and resolve this in a way that benefits everybody. So again, I think there's a good bit of applicability to this technology pre and post court, post filing that I think we could hopefully use across the state.
Yeah, absolutely. I want to open it up so other people have a chance to hear, to ask their own questions if anybody has any. I'm more than happy to keep asking him questions.
Yeah.
But anyone?
Yes, and I see one. There's a question in the chat box that that some states have laws that kind of require a hospital check to see about certain insurance or TennCare or other sort of benefits that they should I guess credit against a particular bill. And yes, and I can say, at least from, I guess, anecdotally from speaking with, I'm not going to share any of the private conversations that our partner has had with us about kind of their collection practices, but that, they attempt to do that. They want to do that. But sometimes there is just a cessation of communication that a hospital, again, they might be perfectly willing to, and also in addition to any benefits that might be already out there to credit against a bill, many providers would love, and I won't say, what I've heard a few different ones say they'd be willing to cut, but they might be willing to cut a huge chunk of that bill just to resolve it. So again, it's all right. You have this hospital that's willing to substantially reduce this bill, or this provider. They might be required to under the law. They might be required to by their internal policies. They might be just willing to for their collection practices. But there is the lack of communication and the lack of representation of that particular defendant who doesn't have counsel and can't force their hand to do that, oftentimes, or just facilitate that discussion. So it's a great point, but from what we've heard is that, again, the hospital the provider wants to be able to engage in some of these discussions. They're just unable to do so. I'll share with you a little bit about some of the of our initial kind of sample set. We've had, where's my statistics that I've written? We've had a couple different cycles of beta testing for this software. It was, again, I told you it was one of the first in the country. The developer of the software is the largest online dispute developer in the country. And so they've kind of had to develop this for us. I won't say from scratch, but because they haven't really done any pre-suit portals like this, it has taken a lot of time and effort on their part. We also received a grant from SJI to pay that provider. And so of the close to 40 folks that were selected to participate in this very, very early beta testing, these were individuals that have gone through the typical collection processes of the particular provider here. So they have, whatever that process is, a first phone call, then a letter, then another phone call, so they've been through this process and there has been no response from the debtor. Of those 40 folks, being invited to this ODR, online dispute portal, has resulted in a 30% engagement rate. So again, these are folks that otherwise would have been taken to court, and simply having the ability to resolve this dispute online and being invited to do that, and I'll talk a little bit about the invitation, has resulted in 30% of them, I would say positively, amicably resolving that dispute by agreement between the parties. And that resolution could look like a payment plan, could look like a dismissal of the outright claim, could look like a insurance settlement, could look like charity care write-off benefits that they were willing, the hospital was, or as the previous questioner mentioned, that the debtor might have been entitled to. So those resolutions take place by way of written agreement outside the portal, but they've also taken place by way of a settlement agreement that has actually been generated inside the portal. And so I didn't really talk about that, but ultimately this portal, what it will look like is, one, if you're brought to the two parties are brought together on this very, of course I don't have my cell phone here, this very mobile friendly online kind of mediation center with the mediator that's able to step in and help. Those discussions can take place via telephone, they can take place via text messaging, which I'm sure anyone that with kids now know that no one talks on the phone anymore. So again, these messages can all occur, this communication, on a very easy texting type platform. But ultimately, a settlement agreement can be populated and will be populated by this portal for the parties to sign with whatever payment arrangements, whatever payment plan, whatever dismissal of a claim that might result in that arrangement. They can do it all on the portal. A mediator has the ability to talk privately with one side. They can decide to have a telephone call if they don't want to do it on the portal. But there are a lot of different ways. And again, I think of our very small sample set, a 30% engagement rate, or 30% of folks who would have otherwise had up to $25,000 judgments against them, and all the negative consequences that flowed from there. So I am happy to this. Obviously, we have not done much promotion, but we did get word from one of the hospital providers after I guess an initial press release went out about a month ago, they actually received a phone call from someone whose bill had not even been generated, saying, "I saw you in the newspaper. There's some online thing I can resolve my debt. What do I need to do?" So to me, I mean, again, that's just one story, but to me, that's very promising that you're actually getting debtors and being financially responsible and taking the initiative to try to resolve an outstanding debt and to try to negotiate their bill.
So we have a question in the chat from Brenda Gadd about Cities for Financial Empowerment doing a project with the city of Chattanooga, and wondering if this is the same effort or a complementary effort. And then Laura dropped a link there to the project, which is called the Local Consumer Financial Protection Initiative. So I'm not sure. Are you familiar with that, Alex?
So I am trying to see this. Let us see.
So they're launching, it looks like, a local office of consumer protection for consumer.
Yeah, it's supposed to be within the city government, or within the city's office. I think it was started in the last administration, and Mayor Kelly's continuing. I was just curious if it was the same initiative, if it's going to be kind of complementary, because anyways, just out of curiosity, I have no dog in that hunt. Just curious.
Yeah,
love the work that you're doing. So thank you so much.
No, and there are certainly, and I'm reading about this there are certainly outside mediation opportunities available for all sorts of debt in Chattanooga. This is one that there is no requirement that that even the mediator be local. I mean, we're having mediators from Memphis, Nashville, all attempt to use the service. But no, at this time, this is a separate initiative. It's not related in any way. It's a pilot that's literally being developed by the Supreme Court, Legal Aid, and Hamilton County Sessions Court, as well as Erlanger.
Thank you so much.
So we're coming up on time here. I do want to just ask one really broad question, because you have such a unique perspective that I think a lot of folks that are more like in the health policy space or financial security space don't often get to hear from. But, you know, as we are sort of emerging, hopefully, from the pandemic, are there any issues that sort of you see coming down the pike or you fear are coming down? I know you were talking about some things before other folks joined, and I know people would be interested to hear some of that.
Yeah, certainly. And again, at this time, it's somewhat anecdotal. I went to pull, we spent a lot of time, again, with this pilot, which kind of was with birth pre-pandemic. We spent a lot of time measuring a lot of different data with respect to these providers, default judgment rates, the number of claims that were filed, excuse me, the number of motions to reduce payments that were and release garnishments that were filed. We spent a lot of time kind of collecting pre-pilot data with the thought of, you know, trying to measure the success of this by collecting post-pilot data, and then the pandemic hit. And so again, I'm sure it's folks were aware, you know, numbers of filings dropped exponentially at the beginning of the pandemic. And as everyone saw, you know, a lot of courts were closed. And then when filings did pick up, those court cases were passed and have been passed for some of them over a year. So you have kind of a very, very clogged court system, which again, you know, more reason to try to use any resources that we have to try to, you know, clear up this backlog. And this backlog is across courts in Tennessee that have waited. You know, the first jury trial, at least on the criminal side in Hamilton County, didn't take place till, you know, last week. You know, that's been a year and a half, and just imagine the number of trials. And as you can imagine, there is some incentive for defendants when cases have been pending for years and years to take their suit to trial, because a lot of the witnesses don't remember what happened. You know, so again, I anticipate a large number of cases actually going to trial, further clogging the court's dockets. The Supreme Court has actually offered some alternative dispute resolution kind of mediation services through the Tennessee Supreme Court and Administrative Office of the Courts to step in, even on the General Sessions level, and to try to help take these cases outside of the courtroom to see if they can be resolved through some sort of mediation. And again, this project kind of works, you know, in concert with those efforts, hopefully in the months to come. It is still limited to one provider, but I am hopeful that the other providers in the area would love to, you know, are going to ask to join the pilot, because hopefully they see some good data and good success that kind of show in their own business interests why this could be beneficial for them to participate as well. But post-pandemic, when I worry about court backlog, I worry about increase, and I'm sure that Sycamore is going to be looking at this continuously, but all of the effects of the last year and a half, what it has done on folks' finances. We have had, you know, I think a lot of there have been many plaintiffs that have been agreeable to work with debtors and defendants during this time, but that agreement's not going to continue. I mean, I think when you look at any area from evictions to any sort of consumer debt or medical debt, I think we're going to start seeing a deluge of filings. And again, you know, these, you know, all of the, you know, all of your graphics that we started with, I think are going to be an even bigger issue, because folks again have kind of kicked the bucket down the road and are in no better financial position than they were previously. I think certainly some of the stimulus payments and such and employment benefits have assisted, but obviously those have lapsed. And as lawsuits start filing, I think people are going to be in similar situations as they were pre-pandemic, if not worse. So again, I'm worried about what we're going to be seeing in our courts. I'm worried about folks again having access to legal representation or realizing that they have access to those, and at least, you know, if I can get somebody, you know, and again, if you think about it, if you step back, I mean, we require somebody who needs to be working and to pay off some debt. We require them to take a day off to come to a docket call docket, then have their case reset, take another day off to come and resolve this dispute. A lot of folks can't even afford to take that time off of work. And so again, they let these judgment rates, these default judgments go down against them. So what if we are able to facilitate court and facilitate resolution to cases, at midnight when someone laying in their bed, being able, just got off of whatever second or third shift, and they're able to negotiate with a plaintiff on their telephone, and so that is kind of what I'm hopeful for. I would hope this is an opportune time to see other ways that our courts can enter. I think there's a funny graphic I know we use sometimes with Supreme Court that, you look at a medical emergency room from 50 years ago and then look at it today, vast different pictures you can see in your mind. You look at a courtroom from 50 years ago and look at it today, it looks the exact same. It operates the exact same. We have not innovated as a court system that in the ways that other industries have. And I think now's the time to start innovating, but also trying to help ensure that everyone has access to justice and that justice is being done and folks aren't being taken advantage of. So anyway, I can ramble on and on. I'm sorry for doing that.
I wouldn't call it rambling. You just have a lot of good information in your brain. Thank you so much for spending the time with us today. I hope that folks got something out of this. Be on the lookout for more events, please. And I think you'll also receive a survey after this is over, just to give us a little bit of feedback on how to make these events better and continue to bring you good information. So thank you again, Alex. I really appreciate it. Thank you for taking the time for being here today, everybody.